Good morning, ladies and gentlemen. It's a pleasure to be here this morning to talk to you about data protection and privacy, which is a very topical issue right now around the world, and even more particularly within our region. So a little bit of background about myself. I'm a director with PwC in the Nairobi office. I head up a team called the Legal Business Solutions team. So that's us lawyers also, putting out that we also know how to help you in terms of business solutions. So if your interaction with lawyers is usually around disputes and going to court, or when you have a problem with the police, we're not that kind of lawyer. So we're lawyers that focus helping you with business issues, commercial issues, and helping you think how to navigate those issues and mitigate legal risk. So I'm a lawyer by profession, have been for more than 20 years. During my career, I have worked for law firms, I've worked for banks, and now my latest incarnation, I'm a consultant. But through all of that, I've always dealt with legal and compliance matters. And core to that is understanding when new laws are introduced or even existing laws are amended, they're going to have an impact on any business. You may have to change the way you do things. And this law, data protection and privacy law, is that kind of law that has very material and significant implications for the way you do business. And the reason for that is, at the essence of this law is how you use people's information. At the center of it is what you will call personal data, which is in relation to individuals, that is natural persons, who are known under this law as data subjects. So when you think about yourself as an individual, and if you think about your day-to-day habits, whether it is you going on social media, whether it's Facebook, whether it's Instagram, and you're posting information about yourself. You're sharing with people details about your life. You put pictures of your children, for those of you who have children. You put, you disclose things that you like about yourself. And it seems fun, it seems a way of letting people know what's going on with your life, and may appear even harmless. But when you think about it, you're not sure how many people in this online environment, which has no borders, how many people have access to your information, that which you're putting online. As a parent, how many people have access to that information you're putting about your children, or that your own children are putting about themselves online? What do they do with that information? And when you start thinking about some of the things also that happen, for example, if you're doing mobile banking, in Kenya, we've got a lot of SIM fraud. People can clean out your wallets and you're not quite sure how they manage to get your details. You'll call up the Safaricom or Airtel. I know here you have MTN. And you will ask them, how did someone have access to my wallet to clean out the funds that were sitting in that wallet? So things like that, you start exposing yourself to a lot of risk that perhaps never existed when you didn't have an online identity and you aren't interacting in the online environment. So what that then has created is a lot of pressure on governments to start protecting their citizens. And basically knowing that even as government encourages use of digital services, a lot of governments are going online in terms of the public services that they provide you with. So it's not just the private sector, it's also the public sector. So soon, all of our information is going to exist in the online environment. But there's a quid pro quo. There's a lot of risk that comes with that online environment, which you as an individual cannot control for. You can't protect yourself as much as you might want to. The crooks, the cyber fraudsters are smarter than any one of us in this room, are smarter than the guys in government. But something still needs to be done. So one tool the government will use is to create a law that helps to mitigate that risk. that law will try and shift responsibility for coming up with measures to that entity that probably has the means to do that. So it's not me, but it's the entity that you've given your information that probably has a better chance of being able to put in place measures to protect that information it has collected from you. So that's a background context as to why are we here in the first place. So if we just turn to the slide, broadly, what are the underlying, factors? I've given somewhat of a context. In a way, you can sort of classify them under two broad justifications. One, because now there is a law, then you must comply. So legal reasons that underlie why this law is important for you to understand. Article 23 of the Rwanda Constitution will provide each citizen with a right to privacy. And included in that right to privacy is privacy of information. When you have a constitutional right, you need a statutory framework to give effect to that right. Statutory framework means that act of parliament, which is the Data Protection and Privacy Law. It is expounding that right that you have under the Constitution to have your information kept private. And so this law is about giving effect to your constitutional right. And that in itself is also Rwanda, also complying with its international obligations. These principles around privacy are also drawn from international treaties, the United Nations Charter for Human Rights, on human rights. So international obligations by your government, they download them, they become domestic rights that are afforded to citizens, and you create a law that gives effect to that right. And that law will come with penalties, there will be a regulator, and so if only just to avoid the sanctions from the regulator, you comply. But perhaps more importantly is the fact that it makes good business sense. Now you as a business person, or you as a provider of services, you count a lot on the people you provide services to be able to feel they can trust you and can share the information with you. And be reassured that when you have collected the information and the way you use that information is actually also in their interest. And so the trust factor comes in. And then the minute that trust is breached, you find there's a hacking incident, your information is stolen, people go up and create, fake identities using your profiles. You may end up losing money in the process, or worse could happen. That you feel a fundamental violation of trust because you were counting on these organizations to use your information in an ethical manner, in an appropriate manner, in a legitimate manner, and in a manner that ensures that the information is also safeguarded when it's under their control. So from a business perspective, that customer trust is key for you to be a sustainable business. And if you violate that trust, they will go to their feet and go elsewhere. So that then sort of brings us to the question as to what are the significant risks then of not observing this law and or otherwise promoting the privacy of people's information. So risks of non-compliance. Rwanda is very much a compliance culture. When we stereotype each other in the region, I'm sure you all have your own perception of what Kenyans are. Kenyans just seem to there's no structure, there's no order. They're just aggressive, maybe they're seen as pushy, and sometimes you wonder how does this country work? How does it manage to work the way it works? Right? To give an example, when our own law was being drafted, and then when they drafted the penalties for breaching that law, Initially, the penalty had been drafted as you will pay 5 million shillings or 1% of your annual turnover, whichever is higher. That was when it was a draft. As soon as it went to the government printers and came out on the other side as an act of parliament, someone substituted the word higher with the lesser. That's how serious we get. Meaning that 5 million shillings now, instead of being the floor, the minimum was the cap. So you ask yourself, if I'm a very large enterprise, I'm generating billions of shillings in turnover, and I'm found to breach, and the sanction I'm exposed to is 5 million shillings, how have you driven my conduct to comply? The Rwandans didn't make that mistake. When they drafted your law, as a corporate entity, you weren't even given the option of a fixed fine. They went straight to turnover. And so, for certain administrative misconducts, and we'll talk about what those are, your regulator can fine you 1% of your global annual turnover from the previous financial year. That's the fine as a corporate entity. If you are an individual, because individuals can also, are capable also of breaching this act, the fine is 25 million Rwanda francs and a possible imprisonment term of up to 10 years. So very, very heavy penalties for breaching this legislation. If you are fortunate to be sued in court for a more serious violation of the law, then the court can fine you 5% of your annual turnover from your previous financial year. So depending on the size of your business, this could be a very significant penalty and financial implication for you. So one risk of not following this law is the fact that the regulator can take action and you may face fines that are extremely punitive. The other, of course, is reputational risk. As I mentioned, people will vote their feet if they're not happy with the way you're dealing with their information. And in this day and age, when people are very quick to go onto Twitter, social media, what's that old adage that it takes years to build your reputation and it takes one day to lose it? And we've seen that time and time again reflected. You just need to read the newspapers. So if you're constantly in the news as a violator, the regulator has taken action against you. People are complaining about your services on Twitter and the fact that the information isn't safe with you. Over time, you're going to see that impacted in the ability of your business to survive. Reputational risk will also effectively disable your business. Financial and criminal risk, we talked about the fines, but also think about that the fact that you have to pay lawyers. If you find yourself caught up in litigation because you've been sued, you're going to have to spend money to defend yourself. In addition, if you have to take remediative steps, then you're going to also have to spend money that perhaps you had not intended to spend. So there's a financial consequence to not complying with the law. And as I said, there's as an individual, there's a potential risk of imprisonment. Operational risk means that, in a sense, one of the sanctions coming out of a violation, either from the regulator or even from the courts, or even the individuals themselves you collected information from, is that they can insist that you don't use their information further. Now, if your entire business is based on being able to process information that you've obtained from your customers, if you're injuncted or prevented from using that information, it will have serious implications for your ability to operate on a day-to-day basis. So there are significant operational risks that also come from not complying with the law. At the very least, if you have to take those remediation steps, as management, you have to pause, stop focusing on how you're going to grow the business, and use all of your management time to now try and figure out how you're going to deal with this risk. So again, do you want that business interruption because you failed in the first place to understand what this law requires you to do and put in place the measures to help you comply with the law. So there are significant consequences to non-compliance. We'll just talk a little bit about, some of the highlights of this law. It is quite a detailed law, so we're not going to necessarily be able to cover everything, but we just hope that this gives you a flavor of some of the more important aspects of the law. It is important to understand that the way data protection laws, they have a common DNA, if you will. A lot of the modern data protection and privacy laws that you're seeing being rolled out, many of them are drawing from the European law, known as the GDPR, the General Data Protection Regulation. That came into force it was passed in 2016, and just like in Rwanda, organizations in Europe were given 2 years to prepare for compliance, and it became effective in 2018. So you'll see a lot of similarities between the Rwanda law and the GDPR, but they're not necessarily identical in every respect. So you still have to be cognizant of the areas in which the Rwanda law differs from the GDPR. If you look at it more generally, and when you think about what are the core aspects or themes that are reflected in the law, we've talked about the fact that there are potential large fines and scope for imprisonment. So the structure there are penalties that have been prescribed into the law. There are multiple bases on the basis on which you can process information, and we'll talk about that, those multiple lawful bases. There are prescriptions around how you can collect data and what you need to do when collecting data. There'll be rules around when data can be transferred outside Rwanda and the things you need to demonstrate in order to be able to transfer information outside Rwanda. The law will prescribe certain rights that individuals who collect information from enjoy and can enforce against you as an organization. There will be requirements about putting in place security safeguards for that information that you've collected and that you're using. You must understand the information that you've actually collected and that you use, and that's what the purpose of creating an inventory is about. A core obligation, and which is probably more immediate at the moment, is to register with the regulator as a data controller and processor and find out what that means. And then there are those obligations on you as an organization that does control information. So what are your obligations as a data controller? The requirement that every time you're going to implement, say, a new process or perhaps change a system on which information sits, you have to make an assessment whether there's any risk to that personal information that sits on that system, or any risk to any information you might need to introduce a new process or a new product. Maybe you're developing a new product, and in that designing that product or implementing it, it will require you to use people's information. You have to ask yourself, is this information safe even as I design this product, or am I designing a product that actually puts people more at risk? So that requirement to undertake impact assessment is another key feature of data protection legislation. And then Rwanda has a unique right to designate somebody to inherit your data. I haven't seen that under Kenyan law or under GDPR. So I guess it's one of those differences I was talking about that time will tell, how is it going to be interpreted. Your courts are going to provide inputs. Your regulator will probably issue some guidelines as to what's anticipated in that rule. But I think the point is to note that there's still a lot that needs to be fleshed out about this law. There is a lot you can comply with. There are other situations where it's going to be very confusing and there's no clear guidance on how best to practically comply. And it will take time. So you may not have all the answers to your questions today or anytime soon. It is only when you start actually interacting with this law, the regulator themselves also starts understanding the full implications of the law on business, that you can then hope that certain things will be clarified, certain things will be changed and amended, and at some point in time then, it will be quite routine to comply with this law. Let's move on. So going to some core definitions. maybe some of you in the room already have heard of these terms being used. I mentioned that the rules govern a data subject. A data subject is every one of us in this room in our individual capacity. We are the entire reason this law exists, us as individuals. We are the ones who the rights of whom this law is designed to protect. The important thing to note here is that a data subject cannot be a corporate entity under Rwandan law. It is an individual. So this is not really about protecting your corporate information as a business. This is about protecting your individual your information as a human being. You are the data subject. And the information that is being protected is known as personal data, which is essentially any information that can be used to identify you. And when you think about what that information is, some is obvious: your name, your address, maybe where you work. Some things are obvious. But then there are others that are not immediately obvious. If I happen to be walking in a building and you capture my image on a CCTV, that image is my personal data, because it can be used to identify me. If I put on my geolocation settings on my smartphone and you're able to track my movements, that's information about me. And the IP address, when I'm sending out emails, that's personal data about me. Your biometric information, those fingerprints on you, that's personal information. So there's a whole lot of data points, as they call them, that can be used to create a profile about me and basically track me or monitor me. All that is personal data. So it's a very broad definition. Now, certain types of personal data are seen to be of more importance, in the sense that if that information is misused, it can have very serious consequences on the individual. It's information that could be used to discriminate against you. It's information that could potentially be used to cause you harm. So that category of personal data is known as sensitive personal data. And the law lists out what that information is. So information about your race, information about your health status, information about your criminal history, your medical records, social origin, religious or philosophical beliefs, political opinions, genetic or biometric information about your sexual life, and also information around your family. So it deserves a higher degree of protection, and in many occasions, you cannot just process that data unless you can demonstrate a specific reason allowed by the law to process that information. And we'll talk a little bit about that. Just move on. The other key aspect of a data protection law is that they're founded on basic principles, or foundational principles. They're known as the data protection principles. At the very least, understand these principles, because they'll help you have a broader understanding of why the law is structured the way it is and why it's applied the way it is. So the first principle is that personal data should be processed in a lawful, fair, and transparent manner. Lawfulness, will come to that. The law has prescribed certain grounds that make it lawful for you to process data. Fairness and transparency is really around what I was talking about, the trust factor. When I give you my information, I'm trusting that you're going to deal with this information in an ethical and legitimate manner, in a manner that is fair to me, in a manner that is clear to me. So the principle there is really being about be open with the people you collect information from as to why you collect that information, what you intend to do with that information, and also how you intend to keep that information safe. Fairness, transparency, lawfulness. The other core principle that you apply when processing personal data is that you should be very specific about the purposes that you collect and process that information. So specific means people need to know. List out, go back, sit down, think in the context of your own business operations, what are the reasons we are collecting this information for? What are the reasons that we are using this information for? And list those out. That is now being specific about the purposes that you collect personal data and that you process personal data. Related to that is the principle around data minimization. The idea here is limit yourself to only collecting and processing data that is relevant to the purposes you specified. The rule there is essentially intended to get you to think, don't collect excess information. Don't collect irrelevant information. If it's not relevant to the purposes that you specified, don't collect it, don't process it. Ensure that information that you process, or that you collect and process, is also accurate. Accuracy is key, and during the time that it's under your control or that you're handling that data, have a process internally of always ensuring that it is accurate, right? Only keep the information for as long as you need it in relation to the purposes that you had specified. If you no longer need to hold on to personal data, either delete it or convert it into a form that is anonymous. It's called the de-identification. And of course, when you process it, do so having regard to the rights of the data subjects, which we'll talk. Maybe we just go one step back. I don't think I finished talking about all the definitions. I talked about data subjects and personal data and sensitive personal data. Data controllers are now you wearing your organizational hat. Basically, and it could also be an individual. You know, if you're in the business of, as Joseph Githaiga, you're a legal practitioner or you're running a small business and you haven't incorporated, but nonetheless your business involves collecting people's information, processing it, you can still be a data controller. The key thing that defines you as a controller is whether you're the one that determines why you're collecting the information and how you're going to process that information. If you tick those two boxes, you're a controller. That distinguishes you from a processor, because a processor processes information on behalf of a controller. So processors are typically third-party service providers. If you run a cloud hosting business, you're usually a B2B business. Your clients are corporate clients. They come to you because they want you to host their data on your server. And they give you access to their data specifically to provide the hosting service. So you are not the one that went to their customers and identified their customers and determined why you are going to collect data from their customers and what you're going to. They've already done that. That they just need you to provide them with a service that relates to that data. That makes them a processor. And we'll find what sort of obligations flow from acting as a processor. Same thing if you are a marketing agency and your client gives you access to certain customer information because they want you to come up with a new marketing campaign. And you need specific details around those customers to develop that campaign. In those circumstances, that would make you a processor. If you also provide payroll services, you know, people outsource handling of payroll to you, you're most likely a data processor, because the only reason you are given access to the employee information is to process payroll in accordance with the instructions of your corporate client. Processing is essentially anything you can do with personal data, from the way you collect it, how you store it, how you edit it, who you share it with, whether you delete it. So any operation you can apply to personal data is known as processing. So we'll just move on to discuss the principles. The other key thing that you need to understand about data protection laws is they confer rights on individuals. This is also at the heart of this law. So what rights do you enjoy as an individual under this law? I have a right to be informed about the uses to which you put my personal data to. I have a right to access the personal data that you hold about me. I also have a right to object to you processing all or some of my data, my personal data. I have a right to ask you, this is known as a right to portability. I can come and ask you to transmit my data to a different data controller. I may be moving service providers, changing service providers. I have a right to ask you, I'm changing my business relationship to this other provider. Please, the information you have about me, please send over to. And when that information is sent, it has to be done so in a form that is machine readable and that is understandable, that the data subject is able to understand. So there will be some technical rules about even how you package that information and how you make it available. I have a right to have information that is false or misleading rectified. If I notice that you have errors or mistakes or inaccuracies in the information you're holding about me, I have a right to ask you to correct it. In some circumstances, particularly where maybe you got the information illegally, or you no longer need that information about me, I can insist that you erase it. So the right to erasure. Also, I have a right not to be subjected to automatic decision making. This is relevant, and especially for the people in this room, where technology is getting to a stage where less and less processing is done by human beings. And more processing is also done by software. There's an ongoing conversation around the ethics of artificial intelligence. You know, those algorithms could have embedded biases. And so you will apply for a service that is automated. A decision will be made, you'll be denied a loan, or you'll be denied some sort of service, but you have no idea why specifically you are denied that service. And nobody in the organization, when you call, they tell you, oh, that's, your information is run through a system. And the system just gives us who has been shortlisted. So maybe you are applying for a job, and you're seeing a lot of companies now employing software that is the one that sort of scans and analyzes CVs that have been submitted and automatically shortlists who should go to the next stage. So what the law is saying here is, if as an organization you do use that software that profiles the individuals that you collect information from, you're obligated to inform them that you do use that software. They could be subjected to a process such as that. And if they have concerns, then they can contact a human being who they can then ask to review the decisions made by the automated services. So it's really more of tell me that you can profile me in this, or you use tools that profile me in this way, so that I have an opportunity to challenge if I'm not happy with the decision that has been made by the tools. I have a right to ask you to restrict how you process my information, even for a period of time. Maybe I've noticed that the information doesn't look accurate, and I want to verify whether it's accurate. I can tell you, in the meantime, please do not process that information. Don't share it. Don't use it to analyze whether or not I should get a service from you. Hold off doing anything with that information until such time that I'm able to verify whether it is accurate. It may require that maybe you move that information off the existing system and maybe temporarily hold it in a different system. But I have that right to ask you to restrict how you process my data. So these are the core rights provided under the law. As I said, there are a couple of other ones under Rwanda law. Right to inherit personal data. I think there's also a right to representation. So some of those, many of these rights are quite common with the GDPR. So there's a lot of literature around how you interpret these rights and a lot of guidance. But where local law sometimes creates a new rule or a slightly different rule, then we don't have a lot of guidance as to what that particular rule might mean. And that's going to prove a challenge, not just in Rwanda, we've seen it also in Kenya, where sometimes our parliamentarians will also craft some clauses and you're not sure what they intended to mean. Legal basis. This takes us back to those data protection principles I talked about. The very first one I mentioned was lawfulness, fairness, and transparency. Lawfulness, this is what that is about. The law requires you to have a lawful basis for processing personal data. The lawful basis could be any one of these that is set out on the screen. Most people assume that you need consent, and so they rush to say, let's put it in the terms and conditions and make the customer consent. If you're going to rely on consent is fantastic because on the face of it, it's very clear they've already given me permission. But consent is technical under this law. There is a concept of is it valid or not. For it to be valid, consent must be freely given. It has to be volunteered. Now, if you make me sign terms and conditions saying, I have agreed, I want the service. So if the only way to get the service is to say yes, you haven't really given me a choice, have you? You made it a condition of your, of you giving me the service that I must say yes. So you won't satisfy the freely given element of consent. Consent also has to be very clear and explicit and equivocal. Meaning, you may have, you can't send me something and say, if I don't hear from you within 10 days, I'll assume you said yes. That's not consent. Yeah? It's not explicit. My silence, just because I didn't say no, doesn't mean I meant yes. So if with your business, you sometimes do those things with your clients, we'll just assume that if you have not objected, then you've agreed. That's not going to be valid consent under the law. Then consent is required to be specific to a purpose. Again, goes back to the importance of specifying the purposes for which you are collecting and processing that information. So that when you're asking me to consent, it's very clear which purpose I'm consenting to. So you can't have a blanket consent, and that again tends to be the challenge sometimes with terms and conditions. By getting your information, you agree we can use your information for everything we desire to do. It won't work. So we usually recommend to businesses that consent should be treated separately from terms and conditions. Because consent also needs to be clearly evidenced. If the regulator comes to them and show me the consent, produce it. You need to be able to demonstrate what that consent could be a form that you have created that allows the person to then select the purpose which they are consenting to. It could be an online. Remember, sometimes you go onto certain websites, they say, click if you want us to proceed. As long as there's a digital footprint of that consent, you can evidence it. But it has to be specific. And so what that means is sometimes you may craft a form and then you list 10 purposes and then you ask the person to sign at the bottom. If my intention was only to agree to 2 purposes, but you haven't given me an ability to, explain that to you, one would get the impression that I've agreed to all 10. So the consent may be valid to 2, but will not be valid for 8. So what you do with the consent, it comes down to how you design it. Put the little checkboxes, yes or no, so that it's very clear to you. He ticked to purpose 1 and purpose 2, and he crossed purposes 3 to 8 or 3 to 10. So this is why I say this law requires you to think how you are doing things currently in your business. It's a very practical law in terms of the things it requires you to do. In the event that you can't demonstrate consent or don't have consent, the law also allows you to process data if you can show it was necessary to achieve any one of these other grounds. So legal obligation is essentially where a law requires you to use data in a particular way. So you're an employer, your employees are also data subjects. There's certain information you're required to give RRA. by law. So as an employee, I can't object to my employer giving that information to RRA because the employer is obligated to by law. It's not a question of me consenting. It is the employer following the law. Maybe the same situation in the context of under your employment legislation. There may be rules around how much, for example, even employee information should be retained for. I can object all I want. You can say you need my permission to keep my information for X period of time. But again, if the law is the one that has prescribed the period, and I have to comply as an employer, I really don't have a choice. It's necessary for me to process the data as a matter of legal obligation, not because of consent. Vital interest is typically the ground you rely on if you process the information in a situation where you needed to save someone's life. So think about someone collapsing in the office, maybe they start having a fit. HR probably has some information that the person has a history of epilepsy. That's a medical condition they suffer from. And when the episode happens, you call the hospital, and then you have to start explaining what you're seeing. The hospital may ask, okay, do you know what you may suffer from? HR has the information sitting on their system, and they go ahead and disclose that actually he suffers epilepsy. And as a result, treatment is had, and your life is saved. You can't come back later and say, what gave you the right to give my information about my medical condition to the hospital? Because in those situations, it was important to save your life. So, or it could even be another person's life. So that's the ground you rely on if it's an emergency situation and a life is at stake. Contractual necessity is where you're able to demonstrate that I have a contract with this individual. I'm required to provide a particular service. And in order for me to perform that obligation to provide the service, it is important that I collect this type of information from this person, or otherwise share this information with a third party. Otherwise, I will not be able to comply with that contractual obligation. What's an example? Again, I'll go back to the employment relationship, because typically that is an agreement. If, as an employer, I have contracted to provide you with medical benefits, now, I'm not an underwriter, but I'll have to deal with an insurance underwriter who has to develop the medical policy and make that available, and then I get to say that I, as an employer, I have given you access to a medical policy, you are covered, so I've fulfilled my contractual obligation to you. Now, for that policy to be issued, certain information about you has to be provided to the underwriter. And so, as an employer, if I share your information with the insurance company, I will be sharing it because it is necessary for me to fulfill my contractual obligation to the employee to provide medical benefits. It's not because the employee gave me permission. As an organization, you don't want to rely on consent as a basis. Because, in fact, one thing I should have said about consent, if you rely on consent, you also have to tell them they can withdraw consent at any time. Now, think how that could affect your operations. Today, I feel like, yes, I'm happy. Tomorrow, I wake up and say, no, I've withdrawn my consent. Maybe by that time, you've already entered into some contract that is reliant on my consent being current. And if it is not, then you create another extra headache for me, right? So it's important to think through which ground are you going to rely on for anything you want to particularly do with the information you've collected, and ensure that it falls within one of these. Legitimate interest is the other one where we see a lot of businesses and also government seeking to rely on, because legitimate interest really goes to what's the reason, you even exist as a business. Day to day, there's so many situations where you need to be processing information in one way or another in order to conduct your business. So you say, it's in our legitimate interest to be processing this information in this way. And the law will say that's fine, but if that's the reason you're going to be relying on, then you also have to weigh what risk is it posing to the person whose information you're using for your legitimate business activities. So it's a balancing act. So you will only be able to rely on it if you can show that your interest overrides that the interest of the individual, in the sense that they're not going to be that harmed. We've actually done an evaluation and worked out that because we need to share this information with these other party, companies that we deal with, in order for us to conduct our businesses, that there's very little risk to this individual. I'll give you an example. Many of us walk into buildings, say a hotel like this, or maybe commercial buildings. And you find that, so if you walk the hotel, you'll have noticed the cameras. So I can bet you, all of you, your images are sitting on the CCTV systems right now. People will be able to see you walked into the Marriott. Sometimes a bit more explicit, you walk up to the security desk, the person tells you, please give us your name and your number and your ID. And they collect those details. In Kenya, we always lie. We give the wrong ID, we give the wrong phone number, because instinctively we're like, we're very distrustful as a society. Why are you asking me for this information? But that's also because we've suffered. There are people sitting in our maximum prison committee sending you SMSs, or please send 10,000 shillings to this number. Or somebody random calls you and you ask yourself, but how did you get my phone number? You call Safaricom and you vent. But maybe it was that guard with that register that, after you left the building, you don't know what is done with that register. How do you know that guard didn't take that information and sell the information? There are people who actively go around buildings purchasing that information. These con men. So that even when they're in prison, they're still earning. So it has made us distrustful. So that is why we go and we give false information at the security desk. Because we don't trust that organization is going to keep that information safe. I feel that I don't know what the risk will be, but I feel that there's a risk. But as the organization, what you'll be saying is, it is exactly for that reason I need your information. I need to know who has come in and be able to ensure this is a safe environment. So, or if there's an incident, I need to account for who came into my building and who did it. We saw this when we had those Al-Shabaab attacks. The last one at the hotel, Dusit. If I walked into Dusit and I went and I registered a false name and a false ID, the event happens. Maybe I told my wife that I'm meeting a client at Dusit. So that she knows he was there. But when they go to their register, they're not going to see a record of my name. Because I lied. I said I was Frobisher. Then Frobisher's wife will panic because apparently Frobisher was at Dusit. Frobisher is the office, just typing away, he doesn't know. But I've gone and said I am him. And so when the newspapers, all these reporters are reporting the incident, they'll be saying, a list of people, blah, 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 there's Frobisher Mugambo. People start fainting in his household. In my household, people think they are safe. But I am the one who went there and I said I'm Frobisher. So, as an organization, they have a legitimate interest in knowing who came into the organization so that they can even take appropriate measures to maintain that safety. Even if it's not extreme as a terrorist incident, think about the number of things that get stolen in offices. Again, maybe that didn't happen in Rwanda, but it certainly happens in Nairobi. Things go missing all the time. How are you going to identify who the thief was if you haven't put in those security measures? So what's the point there? Legitimate interest of the organization in taking those measures and collecting your data. But the organization then has to ask itself, since I've justified it, what's the risk now that I have the information? The risk is, are you monitoring your guards to ensure that they're not selling those registers? Do you have a habit that maybe at the end of every day I need to ensure this register is destroyed, shredded, burnt, so that that information just doesn't remain available for everyone to see? Should I introduce some technology systems where instead of a physical register, somebody is capturing my information on screen, so that means it's not open to the whole world to see? So those are the practical things you now start thinking about if you're going to demonstrate that I have actually weighed the risks to the individual. Public interest is typically a ground that is relied on by government agencies because they've got public authority, and a lot of things they do will generally be more in the public interest, right? In the interest of time, I'll just sort of hurry it on. We had talked about that class of data known as sensitive personal data, and I say the general rule is don't process it unless you can demonstrate one of these grounds. So consent, and again, if you're relying on consent, you should also be informed. So you need to also tell the person what are the implications of consenting to you processing their sensitive personal data. You may also process it where you demonstrate necessity because it's necessary to save a life, vital interest. It's necessary for you as an organization to meet your legal obligations, and also necessary to enable the individual to exercise their rights that they might have against you. Or it's necessary on medical grounds generally. Necessary for preventing or preventative or occupational medicine or public health grounds. So when we are managing the epidemic, for example, your details would probably have been shared with a number of government agencies but we had a public health scare called COVID. We're seeing now in Tanzania, there's an outbreak of Marburg. In Uganda the other day, there was Ebola. So in those situations, if information, your data, if you're in a zone that is potentially exposed and your information is being processed and shared without your consent, and it's maybe even you're demonstrating symptoms, which would be information pertaining to your health and is sensitive. In those circumstances, that is the ground you'd be, the organization will be relying on. And then, for those organizations that are heavily into research and archiving, if you're able to demonstrate that it was necessary in order to maintain records of, certain statistics relating to people that were subject of maybe some sort of study, in that situation also, you can process sensitive personal data if you don't have consent. Children's personal data, and in Rwanda, a child is under 16 years for the purposes of this act. You need parental or guardian consent to process their data, and also you have to ensure that such processing is in the interest of the child. If it is in a situation where life is at stake, the child's life is at stake, in that situation, then you can process the data even if you don't have the consent of the parent or guardian. Rules around transferring data outside of Rwanda. Again, the general rule is either get consent, and it be informed consent, so they must understand the implications of the data being sent outside Rwanda, or if it's not able to be sent, then what will be the implications there, so that they can make an informed decision. Alternatively, there are certain grounds of necessity that you can demonstrate and be able to rely on. The other requirement is that you must get the authorization of the regulator, the Data Protection Office. In order to get that authorization, you need to demonstrate to the regulator that you put in place appropriate safeguards. Now, appropriate safeguards, some of the examples are you've entered into a certain type of contract with the person overseas that you're sending that information with, and that contract has strong provisions imposing obligations around maintaining privacy. So there's certain language that should be used in that contract in order to satisfy that threshold. Or alternatively, you are operating as part of a group organization, and you're sharing data between the different subsidiaries. Sometimes you may, there's a group entity that processes all the information for the entire group, a shared service center sitting in Europe or sitting in Asia. Again, is there an internal policy that governs how entities in different countries within the group are going to share information? It's known as binding corporate rules. And again, your regulator will want to see that and analyze that in order to be assured that the information is being controlled. The other basis is when the regulator themselves have told you it is okay to share information into this other country because they have a law similar to ours and that provides similar protections. So that is known as an adequacy decision. So expect that your regulator will start publishing for you a list of countries that is okay to send data to, because the regulator has taken the view that the law there is, the legal framework there is robust enough to protect the information. You also are required under the law to put in place certain technical and organizational measures. Some of these are, registration, again, critical thing that you must do. You must appoint a data protection officer. The DPO cannot be a junior resource. Your regulator expects that you're going to put somebody who has clout in the organization, who can make decisions, and who has the support of management and the board. So essentially a senior role. You have to also create a record of the processing activities. That is, all the activities that you use personal data for. So that's another requirement. Security measures, really this is sort of going to largely your cybersecurity environment. What sort of systems you are using, encryption, are you using password protection, your passwords multi-factor authenticated. So they're really looking at all those controls that relate to your systems and how information is kept safe. You do pen testing just to check the robustness of your system. So that's required to be put in. But also physical security. Could be, do you have shredders in the office? So because do you have a clean desk policy where information should just not lie around that contains people's information? So you have to think about the physical environment and what physical security controls you need to put in. You also need to think about the digital environment and what security measures you're embedding in your systems. And then, as I mentioned, there's this concept of data protection impact assessments, where you're required to, every time you're introducing a new process, a new product, or upgrading a system, there's any activity that's going to potentially pose a high risk to the privacy of the information that's sitting on that system. You have to do a data protection impact assessment and come up with mitigations if you confirm that there is indeed a high risk to that data. Potential pain points. This is just broadly within an organizational environment where you sometimes think the issues might be. HR, because you process a lot of employee data, so think how are HR personnel managing your information? We mentioned the CCTV. If you are capturing people's images, how long are you keeping it there? And how are you keeping it safe? Marketing, because we like blasting, there's a rule that you should not directly market to customers unless you have their consent. That's going to be very inconvenient for many marketing departments. But you have to demonstrate you have obtained the consent, or maybe there's some other ground allowed by the law where you can rely on. Data subject rights, they have rights, but your obligation is to ensure they can exercise those rights. So have you put in place some mechanisms that enable them? Do you have forms they can fill out when they want to make a request? So having to put those procedures into place. Storage. Depending on how long you've been in existence, you might have information sitting on so many different systems. Some of them may be legacy. You might have information sitting in physical archives. Do you have an idea where all of your information sits? So that if I came today and asked, please give me all the information you have about me, and by the way the law gives you 30 days to comply, I would have an idea where to start. So again, poses practical challenges. Consent poses practical challenges, again, proving that it is valid, also enabling it to be exercised. And then also, just avoiding the urge to collect as much information as you want. We talked about the data minimization principle. That whole articulation of what's the minimum we need, what do we exactly need in order to fulfill this purpose? It's not easy, because you don't really wire yourself to think like that. Sometimes it's how you design those forms, where you're asking the customer to give you all of, the information you need. Whoever designs those forms, if they give you 5 pages of information you need to provide, you ask yourself, do you really need all this information about me to provide me the service that you do? So it's pushing back on you as an organization to work out exactly what you need for the purpose that you have stated. Now, we know that the law is becoming effective on 15th of October. And so there are some tips. This is based off our conversations with the regulator. DPO is a priority, and of course registration. Understand your data, so conduct that personal data inventory. Do impact assessments on any new processes or existing processes where you think there's a potential risk. And ensure that you're continuously training or start training your staff around what the obligations around this law will be. So it's important. Because what will happen is come 15th of October, the assumption is you've had 2 years to prepare yourselves. So it will be very difficult to convince the regulator that you aren't ready for it. Because they'll ask you, but it's been around since 2021. What have you been doing all that time? So these are just some of the things that you could start, even with the 6 months remaining, thinking to start doing. Just move on. Some tips, it's kind of related to the previous slide. Some are already mentioned. By appointing the DPO, developing the data, personal data inventory and register. Start notifying why you collect people's information. There's a document known as a privacy notice that you use to disclose that sort of information. Start responding to requests. You may find now people, once they become aware of their rights, are going to start asking you what you're doing with the information. And so you have to have a process by which you can respond. Do look at your systems. So as I say, the digital security as well as your physical security, start putting in place measures that are designed to reduce the risk. There is a requirement under the law to notify breaches to the regulator within 72 hours. So ensure that you have a procedure internally that helps you identify breaches when they occur, and you're able to report within 72 hours, including with how are you managing the breach, or how do you propose to manage the breach. Third parties, those processors that you engage with, the ones you give access to the systems, to the information relating to your customers and to your employees, start getting into contracts with them. The law requires you to enter into contracts, and those contracts must stipulate what the obligations around data protection and privacy are. And you also need to probably make decisions not to proceed with certain vendors if they can't give you assurance, because otherwise they'll put you at risk as an organization. And if you are the one who is a processor, if that's what your business does, you need to start thinking of how you're going to create those controls also internally in order to persuade or give assurance to your clients that when they give you access to the information, you can actually keep it safe. And then communicate your privacy practices. Don't get lawyers to write your communication practices. Please get somebody who maybe is your communications expert. These are complex concepts. Don't start telling your clients and calling them data subjects. Please use language like you, we care about you. Don't say we care about our data subjects. Your rank and file will not understand, person there is not going to understand what you mean by data subjects. And please do not call yourself data controller in these nice communications. It's about just, use nice language, polite language. Rwandans are very polite people. And then also, from a communications perspective, your law is very explicit. Use the language that the individual interact with best understands. If you need to describe data controller in Kinyarwanda, just find a nice way of just saying that. But some of these communications will need to be in Kinyarwanda, some will need to be in French, and some will need to be in English, depending on who are you interacting with. You have to make it clear and concise for the individuals that you're communicating these practices to. But there are ways of doing it in a language that is not scary, and doesn't make it sound like, you know, you're about to sue them. This slide again just touches on a lot of what I've spoken about, but it's generally the approach that we use as PwC when we come and sit down with you and try and help you understand what the risk is within your internal operating environment. You'll find we'll come and ask you about, does your board and management know about this risk and have they approved the policy? Yeah? Because if your board and management don't know, it's very hard for the rest of the organization to do anything about it. And by law, they're the ones who are going to be on the hook, right? Directors and also senior management. So we'll have a conversation. Do they understand and have they approved a framework to manage this risk? We'll ask you whether a DPO has been appointed. We'll ask you whether training has been done. And we're going to ask you whether other people in the organization have been assigned roles and responsibilities in managing this risk. We'll interrogate you about all the documents that you have. Do you even have a policy? Have you created that privacy notice that you need to inform the individuals that you collect information from? We'll ask you about your systems, the physical security, and also the digital security. Are you encrypting emails? You know, are you employing data loss prevention tools? Are you segregating access to certain systems? Because the receptionist has no need to know every other detail around your customers or even your employees. You have to ensure if it's HR and certain information HR processes, HR has access, the receptionist doesn't. Right? So it's you thinking, just doing that whole analysis. We're going to ask you about whether you created that record of processing activities, whether you even categorize the data and identify whether it's sensitive, because it's sensitive, then you'll have to ensure that certain extra controls are put in place. We'll have that conversation with you. We'll have a conversation about the vendors you use and anybody else that you share data with, and ask you, have you put in place a relevant contract? Might even ask you to see a sample of those contracts, so we can tell for you whether what is in them is adequate. Maybe you need to amend them to include these clauses. And then overall, we'll ask you, because this law will continue evolving. You'll get more guidelines from the regulator. You'll find that matters will start going to court, and the judges are going to make certain decisions. You'll start finding that the law itself will continue to change. So you need to have a process by which you review your compliance framework on maybe an annual basis to see if it's still current. Your own business might change. You might start going into new product areas or new client segments, and you have to ask yourself, these new products or this new type of clients, are they increasing the risk for us? And therefore, do we need to go back to our policies, our procedures, controls, and see whether we need to change those to factor in the new risks? So I've tried to sort of explain what is a very complex area in a way that at least communicates some of the key concepts. As much as it might look scary and daunting, the thing is, once you actually start going through the process and understanding it better, it starts getting less complicated. And as in any case though, we can't avoid it. It's not a choice we've been given. We do have to start doing and taking those measures internally to help us comply and therefore avoid the penalties that come from under the law. But more importantly, ensure that people trust the way we do business with them and that they are safe when we collect the information. Thank you.